I don't mind 5, but I also wanted to get a point of clarification from Commissioner Ian, if I can. Are you trying to save like 3 amendments? All 3 of those you're working on morphing into something else? Or
No, just the one we worked on.
just a 1? So can we move the other ones to tables?
That would be an amendment to the current amendment that is on the table, which is 4 dots or less.
So we could potentially make an amendment to table, to postpone indefinitely 6 amendments right now. Right?
So the current,
Well, what I mean by 6 is not, we could just list the amendments. We would be postponing it indefinitely, which would be C6, C7R, C11, C23, C40, and O1.
so, yeah, so right now we're talking about the 4 votes. So are you making an amendment to the amendment?
Yes.
Okay, so what is your amendment?
I move that we postpone indefinitely C6.
So, yeah, that is not in that, right now we're talking about the 4 votes or less. And then we'll move, depending on if that passes, then we'll go back to the discussion of the 5 votes if 4 votes fails, and then back to the original discussion of the amendment to remove things in general. So, does that clarify? Okay. Commissioner Likens.
Thank you, Madam Chair. This is just a question of process that I'm hoping you can answer, you or Vice Chair Lance.
We'll do our best.
So if we postpone these indefinitely, will any of these be eligible for consideration to go to council?
So we don't have a specific process for going to council. We will need to have a motion to move something onto the council. So my understanding is if we're postponing something indefinitely is taking it off the table completely for
So it
everything.
would not be eligible to go on to council, correct?
That is my understanding unless we were to change essentially the rules of Roberts.
Thank you, I appreciate that.
Absolutely. Commissioner Hannick.
Commissioner Hannick, District 1, on the 4 votes, given the time limitations and we have only a few meetings and how long it's taking at the moment to even get through this process, I would say we should vote no on her process and bring it back again with another change to just bring back the ones we want to. The ones that might be with other ones and name them by number. So say no to the 4 votes carte blanche, but bring back the ones and then take off the table the other 5 votes, but not all of them. That way, we're really salvaging what we really want to focus on and what's meaningful to us. I also would then, in that motion, we could vote no on the 4 votes, bring back a motion that allows us to discuss things to the council at a future point in time. So that would be my recommendation on how to vote, and then let's rework another amendment.
I see no additional discussion, so our vote right now will be on the amendment to the original proposal, or the original motion. So the amendment would be to permanently, or to postpone indefinitely any proposal with 4 dots or less, which includes C6, C7R, and C11. All right, so we'll do cards just because it's easier for counting. All in favor of that motion, please raise your cards.
zoned out what's happening.
All opposed, please raise your cards. All right, and then abstentions. Okay. Back. So that motion passes. So that means we are now going back to, well, no. Yeah, the amendment is amended. Yeah, so we're going to vote again, unless there's additional discussion. Seeing none, we will now take a vote on the motion as amended, which is to postpone indefinitely any proposal with 4 dots or less. Commissioner O'Leary?
Sorry to be late to the game there. I just have a question for Commissioner Gandy. Okay?
So are you looking for a point of clarification?
Yes.
Okay.
You mentioned that you've been working on one of those amendments that had 5 votes. Would we improve efficiencies if we called out the ones that we want to suspend indefinitely, not identified by dots at this point, but by amendment number?
Well, that's why I think we should handle those individually if they're gonna be combined and we can decide, but I think getting rid of right now would help us keep moving on.
Any additional discussion? So all in favor of the amendment to postpone indefinitely any proposal with 4 dots or less, which is C6, C7R, and C11, please raise your cards. All opposed, please raise your cards. And then abstentions. All right, so that motion passes. Vice Chair Lentz.
I move to advance C36, modernization of anti-discrimination language to the ballot.
Seconded.
All right, so we have a motion and a second to move C36, modernization of anti-discrimination language, onto the ballot. Would you like to speak to it?
Yes, I would like to speak to my motion. I'm speaking in support of this motion. To my mind, this is exactly the type of update that is contemplated to be proposed by the Charter Review Commission. Our job in Section 8.40 is to review the Charter to determine its adequacy and suitability to the needs of the county and to propose amendments accordingly. Current Section 9.65, non-discrimination, is no longer adequate or suitable. It's not suitable as it uses outdated terminology such as handicapped. It's not adequate as it lacks the broad anti-discrimination statement we should expect as the governing standard for Pierce County's exercise of its powers and the performance of its duties. Proposal C36 does not require special considerations or privileges be provided to anyone. It simply affirms that the county may not make decisions or take actions such as hiring or firing, the provision of services or access to facilities on the basis of or because of the listed protected classifications. Proposal C36 also confirms in its text that it may not be interpreted to infringe upon, diminish, or impair constitutional rights such as freedom of speech or freedom of religion. C36 is an appropriate update to present to the voters, and I urge a yes vote to advance to the ballot.
All right, and for everyone who finds it helpful, C36 is on page 99 of your packet. So discussion on the motion to move C36 onto the ballot. Commissioner Rogi?
Commissioner Rogi, District 3. I urge a no vote. Just adds vague and expansive language, better left to statute or ordinance. It risks legal conflicts and operational conflicts, embedding politicizing categories and a liberally construct It can create conflicts with state and federal law because this is a 10-year document. The current charter provision is sufficient. Section 9.65 already prohibits discrimination. Inserting vague terms weakens this provision. Anti-discrimination policies evolve, enshrining with today's list and directives, politicizes this process and makes future adjustments require voter approval. Pierce County already has robust protections under anti-discrimination. RCW, Pierce County is 9.6, Title III. We have the Fair Housing State Law. We have Title IX. We have Washington RCW 49.60. So I don't think this is a good proposal to send to the ballot, and I will be voting no.
Commissioner Ferrer and then Commissioner Randall Kelly.
Thank you, Madam Chair. Commissioner Herrera, District 2. I too am against this proposal, C36, because we already have anti-discrimination protections in place and enforcement mechanisms. So adding another layer of restriction appears redundant and may unnecessarily limit the council's flexibility in contracting and governance. If the county is going to prohibit working with companies on discrimination grounds, the standard should be clear, objective, and tied to established legal or regulatory findings, not broad or vague allegations. Otherwise, this amendment risks creating confusion, increasing administrative burden, and reducing the council's ability to make practical decisions in the public's interest. Rather than adopting duplicative restriction, the council should enforce existing anti-discrimination rules. Again, and I'm going to say again, and I addressed this a couple weeks ago, when this was first introduced and proposed by one commissioner, I believe he used the language Trumpism, bigots. That right there shows discrimination in itself. So I guess you can say a few of us feel discriminated against. And again, kind of blows a hole in the whole argument for your anti-discrimination. You also quoted the current New York Mayor, Mamdani, who is currently struggling with anti-Semitism and the Jewish community standing up against him, currently in New York City or Manhattan or wherever he lives. And I believe that your quotes that were made, Free Palestine, is insightful and in violent and hate speech. So that right there, I feel discriminated against. I have Jewish friends, and again, this blows a hole in your case. I don't agree with this. I don't think it's needed, and we already have these protections in place. Thank you so much.
Commissioner Randall Kelly.
Thank you, Madam Chair. Commissioner Randall Kelly, District 4. As the person who brought forth the original amendment that this is modified from, I want to express my deep gratitude to many people on this commission who workshopped it with me and expressed their commitments to their values and to the values of our county, which employs 3,000 people and has almost 1 million people living in it of all different walks of life and backgrounds. And this amendment is improved dramatically. It started out great, and it's gotten a lot better thanks to several hands and several smart people looking at it. And now I can say that it safely would cover the employment and contracting and fair treatment of many people I love and care about, people I'm related to, people that I have cared for deeply in my life, all different racial and ethnic and religious backgrounds. I'm really, really honored to be supporting it, and I believe it will get a majority support tonight, and I look forward to it winning on the ballot as well. And that's it. Thank you very much.
Commissioner Ginn?
Thank you, Commissioner Gann, District 4. Very brief. I think this amendment is the perfect example of fixing something that's broken, because what is not okay, something we've talked about a lot, is the current language in the charter. So I personally feel obligated to do something, and it does include legally definable protected categories in federal and state law, which does reduce county liability. So it's just best practice to align it with law, and I will be supporting it. Thank you.
Commissioner Hannick?
Commissioner Hannick, District 1, by defining and expanding the categories of all the people that we are covering, including family caregiver, we pretty much cover everybody. And on the flip side of discrimination law is the ability for a person that is being discriminated to file a lawsuit. So we've expanded the possibilities of all the different ways that litigation can occur because someone says, I'm a family caregiver and I'm discriminated against. So I am concerned that expanding the definition and then saying that it's liberally construed is not narrowing it down, but expanding the definition, and I am not for this type of expansion.
Commissioner Morawski?
Thank you, Madam Chair. I'm going to have to agree with Commissioner Hannick. The thing is, it's a never-ending vocabulary. I mean, I got to ask myself how long is the list is going to be after the next 10 years. I mean, are we going to add some more? The thing is that you cannot appease everyone in regards to that, and then you can't appease the culture. Every culture, all right, has their different definitions of what they're willing to accept from there. So basically, they're going to look at this as going that now we got to walk on eggshells because now we have to make sure we use the right phrases for the right people who we're speaking with and stuff, and it just doesn't work. In regards to here, you've got some of these phrases here that doesn't even align with people's culture in regards to religion practices. So that's not going to work. In the employment side of the house, I know they have the equal opportunity. I know that HR has their process and training of how to educate people how to work with employees and even employers. But if we take this right now, it's a never-ending lawsuit because no matter what an individual says, somebody's going to be offended about it, and it'll never end. And the list of these different vocabularies is just going to keep expanding to the point where the whole chart is going to be filled with this and not the original one that was already there. So I, Brenda Molesky of District 2, will not be supporting this at all because it doesn't serve a purpose that's going to be a benefit to the individual nor to the employment. Thank you.
Commissioner Fletcher?
Thank you, Chair. Commissioner Fletcher, District 5. I have an amendment to C36.
What's your amendment?
Amendment is strike religious affiliation, insert creed.
Do I have a second for the amendment to strike religious affiliation and insert creed? Second. A second from Commissioner Berge. Would you like to speak to your amendment, Commissioner Fletcher?
Yes, please. Thank you, Chair. I felt like the original word that was contained in 9.65 was respectful to all religions. I feel like this is just my own opinion. Religious affiliation is a bit demeaning. I don't think it really casts a good light on religious affiliation. I don't think it really does justice to what people when they worship and when they pray, when they have these strongly held beliefs. So I feel like creed embodies that better. The rest of this is gobbledygook. I cannot understand what a lot of it means. But I do think it would be a slight improvement if we respect those that adhere to deeply held beliefs, and I think creed is the appropriate way to put that in a document for posterity, not just for the passing moment, but for forever.
discussion strictly on the amendment to strike religious affiliation and replace it with creed. Commissioner Roby?
Thank you, Madam Chair. Commissioner Rogie, District 3, I strongly support this amendment. Thank you.
Any additional discussion? Seeing none. All in favor of the amendment to C36 that would strike religious affiliation and replace with the language creed, please raise your cards. All opposed, please raise your cards. And then abstentions? So that motion passes, so back to discussion of C36 as amended. Any additional discussion? Seeing none, then we will take a roll call vote on the motion to move C36 as amended to the ballot. So, clerk, if you could please call the roll.
Lisa Boyd,
Yes.
George Consuelo,
Aye.
Mason Fletcher,
No.
Kate Ginn,
Aye.
Sharon Hennick,
No.
Caleb Heimlich,
No.
Elizabeth Herrera,
No.
Billy Joe Heatherington,
No.
Jake Hunter,
Yes.
Martha Lance,
Yes.
Justin Layton,
Absolutely yes.
Brenda Likens,
Yes.
Brenda Valesky,
A recorded no.
Jerome O'Leary,
No.
Holly Rogie,
No.
John O'Rourke,
No.
Devin Redell Kelly,
A long overdue, yes.
Troy Surratt,
Yes.
Jen Marie Strickling,
Yes.
Judson Lewis,
No.
Kelsey Barris.
Yes.
I count 11 in favor and 10 opposed.
So that motion passes. Commissioner Layton?
Thank you, Madam Chair. Commissioner Layton, I move C18, juvenile detention oversight, to the ballot.
I have a motion to move C18 to the ballot and a second from, I think, Commissioner Hunter. Sorry, let's go ahead first. Would you like to speak to your motion?
Yeah, thank you. I'm supporting and proposing C18 with my fellow commissioner from District 7, Likens, because at its core, this proposal is about transparency, accountability, and public trust. It is not about taking away authority away from the courts. It is not about infringing with judicial decisions. It is not about transferring control of juvenile detention operations to the executive branch. The Superior Court has expressed concerns that we heard tonight on Proposal C18 create separation of powers issues. I respectfully disagree. Nothing in this proposal, which they were unable to point out, by the way, gives the proposed juvenile detention advocate office the authority to manage detention operations, direct staff, override judges, alter court decisions, or make detention decisions. Judges would continue to exercise their constitutional and statutory responsibilities exactly as they do today. The court would retain authority over juvenile proceedings, detentions, decisions, and court operations. What C18 creates is independent oversight, not operational control, something that we have long overdue for the kids that we keep in custody. There is an important difference between managing a facility and ensuring accountability within the facility. Government across the county recognizes the independent oversight improves public confidence identifies problems before they become crises, and provides an avenue for concerns to be raised outside the chain of command, oversight is not an attack on institutions. It is a safeguard for the institution, the public, and those it serves, as well as the taxpayers that it provides the revenue to operate. The court's presentation highlights many reforms that have occurred over the past 2 decades. I commend those efforts. The reduction in detention population, implementation of evidence-based practices, compliance with PREA standards, and focus on positive youth development are important accomplishments. But the existence of reform is not an argument against independent oversight. In fact, it is an argument for it. If these reforms are working, independent oversight provides an opportunity to validate those successes and demonstrate it to the public. Transparency should not be viewed as a threat. It should be viewed as a strength. C18 also recognizes a simple reality. Youth in detention are among the most vulnerable individuals under government supervision. Their families deserve confidence that concerns can be raised, investigated, and reviewed by an independent office. Staff also benefit from a system that promotes accountability, identifies systematic issues before they become larger problems. The proposal's reporting requirements are equally important. Taxpayers, families, policymakers, and community members should have the access to information regarding facility operations, use of force, room confinement, population characteristics, and rehabilitation outcomes. Public trust is strengthened when information is readily available rather than difficult to obtain. Likewise, independent audits and accreditations, which they can be done, by the way, are standards, best practices in both public and private institutions. If the facility is already meeting high standards, external reviews will confirm that success. If improvements are needed, those reviews will help identify opportunities for continued programs. Finally, we should remember why charter provisions exist. They are not written for today's leadership alone. They are written to establish durable systems of accountability that will serve the public for decades to come, regardless of who occupies positions of authority in the future. C18 does not undermine the judiciary. It does not diminish the court's role. It simply establishes reasonable, independent mechanisms to promote transparency, accountability, and public confidence in a facility that houses some of the most vulnerable youth in Pierce County. For these reasons, I urge the Commission to advance C18 to the voters and allow the people of Pierce County to decide whether these additional accountability measures should become part of our charter. Thank you.
Discussion on the motion to move C18 onto the ballot. Commissioner Rogie?
Thank you, Madam Chair. Commissioner Rogie, District 3. For all of those claims, I believe that this is just another level of bureaucracy that basically has a reporting function, and I believe that it creates unnecessary bureaucracy and new costs. Notice it does not come with a fiscal note or a staffing proposal. This type of requirement does not need to be in a charter. It can be It already is required in several different ways through, as the judges talked about earlier, PREA, and they have to be in compliance with RCWs and statutes. So I believe that this is not juvenile justice reformed, but a layer of bureaucracy that does reports. And it's duplicative of current mechanisms, state requirements. Juvenile detention alternative initiatives have shown significant reduction in detention use. This again has a new expense with no fiscal notes, and I believe in some respects it does undermine the separation of powers and court authority because it is an office under the executive. And while there was a commission here recently, I don't know if it was a commission or a I can't remember what it was called, but they did come together with the executive leaning to talk about the juvenile facility because ultimately the executive facilities maintenance is responsible for that facility. So there are mechanisms already in place. I don't understand why we would want a whole system, a whole staffing system put in place just to do reports. And I believe that it's inappropriate and to put it as a fixed charter mandate for the next 6 years will reduce, it limits the ability to adapt to changing needs and best practices. So I will be voting no, and I urge other commissioners to vote no as well. Thank you.
Commissioner Boyd?
Is it fair to ask questions about this? Or what are we?
We're
just
in.
commenting?
Yes. You can do, yeah. Point of clarification, if it's a very specific question.
Okay. So can I ask the question and you can say if that's a good enough no on that or yes?
Yeah,
Okay.
ask
All
the
right.
question and then I'll tell you.
Okay. So I'm wondering about, are there some existing oversight systems in place right now? It sounds like based on the presentation that there's lots of things moving in the right direction. So is that because there's some oversight right now that is reported and considered? Is that
So I will allow and answer a very short, specific answer to that question. Yeah. So I think to answer your question, Commissioner Moore, I believe the presenter or sorry, I was looking over here.
Boyd,
Boyd.
District 6.
Oh my goodness.
Sorry.
I'm getting so tired.
Madam Chair, I'm sorry.
No, you're fine, Commissioner Boyd. That's my fault. I believe that the presenters did specify one accreditation, but that is, or was it accreditation? I forget what exactly they said. But that is the only thing that they mentioned as something coming close to that. All right. So I saw Commissioner Likens, and then after Commissioner Malowski and Commissioner Consuelo. Commissioner Malowski.
Oh, thank you, Madam Chair. Speaking with Director Gaddis there for the juvenile detention, those are some of the questions I did ask him in regards to that. Yes, we have noticed that they have improved a lot in regards to their functionality and operation, but the one biggest thing that they really have improved on is staying in connection with the parents and the child. They have created a program so that the parents can be able to obtain and receive information in regards to the status of the child, whether it be of a physical need, meaning medical. They are creating a program so that there's an educational process. They have turned things around from what it once was. And I think that is the challenge right now, is that because we haven't done enough research in regards to speaking with the people that's operating this facility, and I think that's the drawback here, is I wish we heard from them in the beginning and not at the end, would give us a better understanding exactly of where that juvenile detention stands today in regards to that. I do know that they do have an internal oversight where the parents have liberal access to that facility, so they know exactly what's going on. They receive the updates regularly in regards to the facility, and they have a process where if there's a complaint, they can submit that. Now, I understand that we're talking about an independent outside oversight committee in regards to that. My concern is because of the sensitivity of the age of the youth and the information and so forth, the Privacy Act is something that I'll be concerned about, and I think the judges brought that as a concern because they want to make sure that the parents and the child is protected, whatever information that may be distributed. So on this note, C18 has some merit, but I could not support C18, so I'm going to say a no to this. Thank you.
Commissioner Consuelo.
Thank you, Madam Chair. Commissioner Consuelo, District 6. I would like to remind folks that even though the judicial/judges oversee the Raymond Hall and they swap out, any litigation would still be putting Pierce County as the one who is the one at fault or would have to take the consequences of that. So I think having additional oversight is beneficial. Again, I'm going to mention being the first, not as in first place, but being the first to take action. I think it's important. I know we have this now, so I'm just reading it over. But there were, apart from the concerns of like disclosure, which could be fixed on the side of the executive, on what information is brought out. Obviously, there's like things like HIPAA and things of that sort. So I'm sure, and working with foster care youth, I know that there's also information that can't be distributed. So I'm sure that is a logistical question that could be solved. And to the point of executive overreach and things of that sort that we've heard a lot throughout this process, we can't put departments or anything like that under the council. So the only place where it can fit is the executive. So I just wanted to place that as a logistical point rather than it being like, oh, we want to consolidate all the power in the executive. If we could give it to the council, that'd be awesome, but we can't according to the charter. It all goes under the executive. So it's not a question of, it being the place where we want it to be. It's really the only place it can go. So.
Commissioner Likens. Thank you, Madam Chair. I want to thank Commissioner Layton for his introduction of the amendment. He did a really nice job summarizing. I also want to thank the Superior Court judges for coming and presenting. But I would like to point out there were a few questions that I had of them, and I'd like to point out a few things. The first is just talking about some financial numbers, and just over the last 4 years, the county has spent $53 million in claim and litigation expenses. Of those $53 million, $21 million were for the sheriff law enforcement, and $11 million were for the juvenile court. There's other various things such as sheriff corrections, which was $5 million. In 2023, there was a $3.6+ million cost to the executive's office for those things. So these are significant costs, in addition to the millions of dollars that they need in liability insurance. So having oversight can lower those costs, and it can lower those insurance costs. But interestingly, when you go to the Pierce County website, and they talk in their report today about how they're addressing operational needs and making improvements in leadership and oversight. In 2026, there was an HR investigation that led to the dismissal of one of the top employees, and it was done by the HR, I believe, office from the executive branch. And in that, and you can go to the Pierce County website, and you can go to juvenile detention, and there is the federally mandated Prison Rape Elimination Act. They talked about the PREA reports that are done every 3 years. So when you pull up the report from 2025, it talks about how they went on the Pierce County Juvenile Court, and I'm reading from that document, was audited from January 30th, 2024 to February 2024, and it led them to receive a recommendation for a 6-month corrective activation plan in that they were in violation. They had to go through, and it lists several bullet points of things that they were not doing, that they need to get into process, and they went through the 6-month corrective process, and they finally passed in June of 2024. There are current things happening within it that we want this to be transparent. We want there to be continuous process improvement. We recognize in putting this forward that the judicial branch is the administrative branch of this program. But oversight is continuous process improvement. And as Commissioner Layton said, these are our most vulnerable residents in Pierce County. It's critically important that we make this as transparent as possible. Thank you.
Commissioner Lentz?
I yield my time. It was just said.
Commissioner O'Leary?
Thank you. Commissioner O'Leary, District incarcerated, obviously they're vulnerable, and you hate to see it. I was amazed to hear the judge here today say that his own son was incarcerated in Raymond Hall. I couldn't imagine what that would be like. But I also have done some research on exactly what has gone on, and the statute of limitations was removed, and many of these claims by one of the other judges' declaration here today came from 2015 or 2016 and before. So it's been a decade since the majority of these claims that, if they're true, are horrendous and should not have happened. But that's not current information. And I think some of the figures you've heard are results of occurrences that happened long ago. This PREA that's being referenced, the Prison Rape Elimination Act, sets national standards for preventing, detecting, and responding to sexual abuse, harassment in all juvenile confinement facilities. It is administered by the Office of Juvenile Justice and Delinquency Prevention. These legally binding rules require facilities to implement strict safety protocols. And these protocols, I'll just touch on the subject matter, I won't go into the details. Mandatory staffing ratios, youth inmate separation, core operational standards, which is very extensive. It goes into mental health, placement, reporting, audits. And for us to form and fund a department that has no jurisdictional authority over the judicial branch is a waste of our resources and our time and the effort that I think we should be focusing on. And not to say that oversight isn't important, transparency isn't important, it absolutely is. But it's being done. And for us to try to implement this new department, reporting to the executive, who has no authority over the judicial branch, makes no sense to me at all. When you have accountability here on a national standard with guidelines that are already in place. And for this amendment to ask about certification from agencies that don't exist makes no sense. So while I want youth to be protected, while it's tragic that they could be incarcerated, while I certainly want to see them rehab and get on the right path, I'm going to be a no vote on this for the reasons that have been stated before me and the ones that I've stated. Thank you very much.
Commissioner Ginn?
Thank you, Madam Chair. Commissioner Ginn, District 4. Pierce County Human Services, I believe I shared before, told me that juvenile detention is the second largest investment that the county makes in our youth. And it seems really odd to me that the executive branch and the council who propose and pass the budget and allocate the funds would not have any say in the administration of the facility and where those funds go when it's that large of an investment, not counting the $11 million in litigation and settlements that Commissioner Likens referenced. I think it was really interesting that the judge stated that courts are designed to be a check, not an administrative tool. To me, that was actually an argument for this because administering a facility is not their area of expertise. I believe in checks and balances requiring an independent oversight body, whether that's under the executive, right, as Commissioner Consuelo said, I don't care where it is, but I believe there should be an independent oversight body to help with that continuous quality improvement, to help with the same thing an ombuds role in correctional facilities helps with, which is pointing things out that are potential for litigation for cost savings down the road. So I think regardless of how much things may have improved today, I don't think the need for the role is going to go away. And there are accreditation bodies other than PREA. PREA pertains to one of many issues, the American Correctional Association. as we can all find out, accredits more than 1,300 juvenile and adult correctional facilities across the U.S. So I don't know why, as a county, we wouldn't want to participate in that. Thank you.
Commissioner Hannick?
Commissioner Hennig, it troubles me that this body of 21 members who are great, who maybe, were good citizens, but we're not stakeholders of the items that we're working on. We are not having extensive expertise, and when we do have expertise come in, we seem to have dismissed them without a full discussion on what the merits of what they bring forth to the table are. So I will be a no vote against this because this is expanding a new bureaucracy. We have not done an in-depth financial analysis. We are putting a burden onto the county, perhaps at a time when we don't have the money to expand to another. Although the idea is a good idea, taking care of juveniles may be a needed idea, but I'm not sure that at this time we should take it to the ballot. And we have not fully explained how we're going to implement the item so that once we set forth and let's say it just gets voted in at the ballot box, is this really prepared to give all the detail on how to implement such procedure when we have not thoroughly investigated it ourselves? So I am concerned that we're putting unfunded mandates onto the council and a program that's just the outcome is what we want. It's an outcome-based thing without giving the details on how we're going to get from A to Z. So I will be against this.
Commissioner Hetherington?
Commissioner Hetherington, District 2, and I think I'm getting grayer by the minute. But to Commissioner Hannick's point, I mean, there's this body, in 6 months, it's hard to dig into the weeds and the details and hear experts and figure out kind of how all this stuff is going to land if implemented. I mean, to Commissioner O'Leary's point, in 2024, what my stuff says, well, my research with House Bill 1618, removing the statute of limitations on these cases and getting and it's not just Raymond Hall. Raymond Hall has the most, but there's just every single juvenile facility in the state has got an influx of these type of cases. And to listen to the judges today say that we're doing such a great job with our diversion programs that I count last Thursday, there was 11 youth in Raymond Hall. I don't know what the fiscal note on something like this will be to stand something up. Will that take away from diversion program, funding for diversion programs, funding for other youth activities to keep kids off the street, keep kids engaged that we need to be, we're already not spending enough money doing. So I'm just having a really hard time with this myself personally, is because I want to protect our youth and I want to do what's right by our youth, but I just don't know if this is right now. We should have had this in the 80s or when something else was when all this stuff was going on. I just don't know. We've changed times since now. We're doing such a great job in diversion. Some might say no, but the numbers are showing that, again, there's only 11 kids in juveniles in Raymond Hall. So
Commissioner Randall Kelly?
Thank you, Commissioner Randall Kelly, District 4. I'm going to try to keep this relatively quick. I think folks, Commissioner Dean and I both referred multiple times over the last few months how we've worked for years, both of us in youth program quality improvements and youth serving organizations. Many of the organizations that I've been involved with or adjacent to are subject to all types of accreditation and are subject to all types of evaluation and analysis. And many of them get county money and get a lot less county money than Raymond Hall does, and are subject to pretty stringent requirements with all that type of stuff. So I don't think it's really unreasonable to have high expectations of the single biggest youth-related cost center for the county that is warehousing youth that have been accused of crime, some of which is quite egregious, and often for very long periods of time. It's completely reasonable to have those types of expectations. I will also say, recently, there has been a huge uptick in youth crime in the county. I think everyone's aware of it. and that led to an outcry, and it's led to a huge uptick in youth programming and night programming and summer late nights. And this is Commissioner Hetherington's point. If that stuff had not gone away in the early 2000s after it was temporarily added in response to gang violence, we would not have had a big upsurge in youth violence more recently. So we shouldn't just be starting things when we need them and then getting rid of them when we think we don't need them anymore. What we need to actually do is build the structures for accountability and transparency and care that endure over the long run. That should really be what our orientation as a government should be. And that's why I'm supporting this.
And he's going to pay for it.
Commissioner Hunter?
Thank you, Madam Chair. Commissioner Hunter, District 4. I just have a couple of notes on this. I'm not shocked that the people who would be subject to this oversight don't want it. And the fact that they don't want this body that would be designed to help them improve the condition of the youth in our care and the facility as well. What does really shock me, though, is to hear that it is too expensive or too bureaucratic to protect kids and children in the county's care. This is the power that this commission has, or at least to send this to the voters. We have the power to add protection to children in our county, and I would encourage all of my commissioners to vote accordingly. Thank you.
Commissioner Rohr?
Commissioner Rohr, District 6. So I commend the reason why this amendment was proposed. Kids are amazing, our youth are amazing. I've been a foster mom for 3 years. I brought them into my house with my own kids and treated them like my own children. But this amendment is I don't believe that it's going to make the process better going forward. I think the process should involve cooperation. It should involve a discussion, and that has not happened. I know I've talked to the sponsors, one of the sponsors of this amendment, and it was like, hey, we talked about it twice before and got nothing, and this is what we're doing. And that lacks care, that lacks respect, appreciation, it lacks real progress. And one of the things I talked about early on was that we can do something like this with the courts, with an MOU, 100%. So I am shocked at the arrogance sometimes that comes along with some proposals. And we're not listening. We're using these amendments to stop listening. I would like it to be where these amendments help us to start working together and talking more together and working to improve conditions. So this is truly an overreach into an area that is already governed by the courts and existing oversight mechanisms. I encourage commissioners to carefully consider the information and analysis provided by our court administrators and judicial partners. They are partners. The charter should establish the framework of government, not prescribe operational oversight structures that may need to evolve over time. To Commissioner, to the good Commissioner Likens' point, that we are in a process of continuous process improvement, which can be handled more appropriately in an MOU. I would love to see that. But to put it in a 10-year framework, permanent structure, cost, is not responsible. It is an unfunded mandate. I believe a lot of the financial facts that are being shared are accurate, but they also reflect that's the impact of decisions that were out of our control or their control, and those things are being dealt with today. But going forward, we have a court administrator and leadership coming before this body saying, we're here. This can be better addressed through policy, administrative practices, intergovernmental collaboration, rather than charter language. And I spoke to King County, so supporters of King County has a model that was developed with significant judicial involvement and safeguards for the judiciary. In fact, Ordinance 13668 preserved authority for a majority of the King County Superior Court judges to trigger reversion of detention administration under certain circumstances. That is very different from us adopting a charter amendment without the request of Pierce County judges or court leadership. I encourage the Commission to carefully consider the information that was provided tonight before moving forward with C18. And I did print a copy of the ordinance. So on November 22nd, 1976, King County Superior Court judges acting under RCW 13.20.60 authorized by majority vote the transfer to the county executive the responsibility for and administration of all non-judicial juvenile court services, which that exists today, but it was done with cooperation. And so I urge you to vote this down.
Vice Chair Lentz? Thank you. I think a lot of the reasons to support this proposal have been stated very eloquently and persuasively. What I'd like to speak to is the nature of the language itself. The proposal, if you look at it, is very high level. It's about as bare bones as it gets to get at the issues that have surfaced. First, it says that there shall be an independent oversight officer that has the ability to investigate and monitor conditions. Then it says that there should be on an annual report, and that the facility should establish and maintain performance measures. And finally, that the facility should be subject to an independent audit or accreditation review every 5 years. Those are not interference into the Superior Court's function or a separation of powers problem. In fact, going to what Commissioner Rohrer said, it actually, to my mind, works hand in hand with cooperation and collaborativeness. By setting these high-level standards that puts the framework around it, that encourages people to work together. And the fact that it's been suggested that nothing needs to be looked at, that things are fixed, I would think the opposite would be true. I would think the Superior Court would welcome something like this and would say, yes, sunshine is the best disinfectant. Let's take a look at what's going on, and we will work together. We welcome an independent body, and we welcome the structure around setting up these types of performance measures. We'd love to submit to an audit every 5 years. I mean, it doesn't have to be expensive. It doesn't have to be complicated. The details are not overly circumscribed in this proposal. Anyway, sorry, it's getting late. I lost my train of thought. I will be supporting this proposal.
Commissioner Strickland?
I
don't feel confident voting one way or the other, so I would like to make a motion to move this to a different day so that I could do more research and feel confident in my decision.
So we have a motion to move discussion of C18s onto a different day. Do you have any more specifics? Onto a different day. I have a second from Commissioner Rohr. Discussion on the amendment, or discussion on the motion to move discussion of C18 onto a different day. I didn't. Yeah.
Point of information,
Yes.
My only hesitation about that would be we've had significant debate about it already, and I'd be curious if we're moving discussion to a different day, like would we be punting on a whole other round of significant debate about it, given our timeline and how much we have to do. That's it.
So I have a motion and a second. Any additional discussion?
30 seconds.
Yeah. Madam Chair.
Yes, Commissioner Molesky?
Thank you so much, Madam Chair. I'm going to have to agree with Commissioner Strickland. Like I stated before, some of the information that was brought to the table are not current of what changes have taken place today. I believe that we should make a decision based on how it stands today. Speaking to the Director Gaddis for 2 months ago, in regards to that, a lot of changes has taken place. The information that was brought to us is not relevant today. The stats in regards to the youth, a couple of months ago was from 20, it's now to 11. That's a significant change, and it's indicated to state that a lot of changes have improved. What you're saying is right. The Superior Court really is not totally involved. They're mostly administrative, but we're failing to realize that they have other staff that runs that facility in addition to that. So the thing is that I want to support Commissioner Strickland on this one. I really think because this is a sensitive issue, that we need to better educate ourselves on this and then decide how we want to move forward on C18.
Commissioner Rohr?
Commissioner Rohr, District 6. I would just say that I don't recall us having significant debate on C18. This was probably our most robust debate that we've had on it, which was great. I also think that we got brand new information, which is great. I think Commissioner Strickland and maybe even others who have questions could get a question or two answered, think about it. This is not a rushed decision. It shouldn't be if it's the right decision. So I support her motion.
Any additional discussion? Commissioner O'Leary?
I'd like to amend her motion that we pick up with this amendment at our next meeting. If that goes through, I'd like to make sure that we start here because that will be fresh in our minds.
So I have an amendment to the motion that would have us first address C18 at our next meeting. So, second from, motion and a second from Commissioner Hetherington. Discussion on that amendment to the motion. Seeing none, all in favor of the amendment to the motion that would require us to talk first about C18 in our next meeting, please raise your cards.
Alrighty.
All opposed, please raise your cards. And I believe if I'm doing math right, that is everyone. So that amendment passes. So now back to discussion of the motion as amended, which is essentially the same. Commissioner Hannick, did you have discussion?
Yes, I just wanted to add that since we've heard from the judges just tonight and having only 10 minutes, including the questions, this gives us a chance to, putting it to next week gives us the chance to be able to ask questions.
It would be
and
next
get the
meeting,
answers.
yes. Which is on Wednesday.
I say next week.
Yep, this week.
All right, Commissioner Willis?
Commissioner Willis, District 3. I would also implore commissioners to look and explore alternatives to putting this into the charter. Through ordinance, MOU, ILA.
Madam Chair, the motion is to postpone definitely to a certain time, so that is what we're talking about.
Right, so
Just
what
postponing it.
I'm explaining is to simply do research with MOU, ILAs, so they can do research to come back with more informed decisions for next debate.
Thank you for that recommendation. All right, additional discussion on the motion.
Commissioner Layton's not happy.
Madam Chair.
Yes, Commissioner Losky.
If it aligns with this motion, or maybe I should ask this a question, would it be a lot easier to have guests come in? That way it'll expedite it a lot quicker, and then the people can ask their questions accordingly? Would that be a lot easier than us trying to interpret what we're reading?
So right now we are in discussion of the motion that is in play right now. So it's not really a time to talk about agenda, but we could do that after.
Okay, thank you.
Yeah. All right. So all in favor of the motion to talk about to suspend C18 discussion until next meeting on Wednesday. All in favor, please raise your cards. All opposed, please raise your cards. 2. All right, so that motion passes. So we will pick C18 back up on Wednesday. Vice Chair Lentz.